Western Wisconsin. He's facing first-degree murder charges related to the death of his wife. And the accusation is that he staged a freak car accident where a pipe went through a windshield to try to disguise the murder of his wife. That's the state's accusation. But the state rested its case this morning, and now we're watching a parade of defense witnesses, including this expert who was just on the stand, an expert in biomechanics, to basically testify in this expert's opinion that the injuries to the wife could have been caused by the pipe going through the windshield. Apparently, forces on the front of the head can cause injuries on the back of the head. The old saying that for every action, there's an equal but opposite reaction. Apparently, this is sort of where they're trying to go in this case this afternoon. Andell Brown is a criminal defense attorney out of Miami Beach, Florida, and he's joining us for a little bit of analysis. Andell, good to see you back here on Law and Crime.
Thanks for having me.
So, this is not a surprise. Competing experts. The state has a medical examiner who's a full-time employee of the state. She said earlier in this case that these injuries could not have been caused by the pipe, and now you have a defense expert saying the exact opposite. Which side does the jury believe?
Well, the jury tends to go with the expert that has the most plausible, clear, and concise explanation. I think when we look here, I heard a lot of your chatters talking about this guy is just using a whole lot of words. It doesn't seem like his message is coming across clear. And I'm talking about the defense's expert. So that may be something that the jury might not really go towards, because they're like, what is this guy talking about?
Yeah, and a lot of people in our chat rooms are just convinced that this defendant is as guilty as the day is long. I'm at least willing to give it a little bit more of a shot. I don't think it's as strong of a case as some of the other trials we've watched here recently, where it's been pretty clear to me that the defendant is guilty. I think this one requires a lot more mental somersaulting here to try to get to the bottom of exactly what happened. But Andell, I'm being told that your camera's not working, so we're going to try to get that back up so we can actually see you as well as hear you. In the meantime, let's listen to some previous testimony. Oh, we have you back apparently now. Maybe we can see you as well as hear you. Do we have? There he is. I see him now. Andell Brown, criminal defense attorney, Miami Beach, where presumably it is warmer than it is today in Manhattan. Let's continue to analyze this. We can see you again. So we've got this defense expert, and a lot of people in the chat room just weren't buying a word that the guy said. And look, this is kind of a far-fetched theory that this pipe went into the windshield and ultimately caused injuries to the front and to the back of the victim's skull. It's kind of hard to get people to believe that one pipe could cause that level of damage.
I mean, that whole pipe scenario is a tough one to swallow, and I think the defense has an uphill battle convincing the jury that that's what happened, or that it's even reasonable. The prosecution's theory that a pipe just doesn't cause that type of damage seems to make a lot more sense, especially when you look at the injuries to the back of the head and the way they were caused, not to mention Mr. Kendhammer's own injuries he had on his hands and other places like that, the scratches on his neck that would indicate some type of a struggle. Even though he's tried to excuse those, I don't think those are going in his favor. We have the war of the experts, which we're all used to in these trials. I just think the prosecution's expert has done a better job than the defense's.
But the flip side of that argument is that the defense did get the state's expert to concede, one, that she has practically no experience with objects going through windshields and causing this kind of an injury. Right. And two, she also said something really interesting that we were keying in on last week, and that's that the victim's injuries could have been caused, in theory, by not fully having a seatbelt on. She said that these types of injuries were very, very common in the days before people wore shoulder harness. If the defense was going to try to go there. But it seems to me that the defense is really staying its course and going along with the defendant's original version of this story, that a pipe went through a windshield and then that's what caused the injuries. So to the defense's credit, it really isn't changing theories. Is the defense worried about losing credibility here if the defense does change theories midstream, basically since the point that the police started investigating the case until where we are right now?
You don't want to change theories of your case midstream unless there's a really high upside. And I don't think I see it here for the defense team. I think what they're looking at is this story is already a little sketchy. And if we push it any further, we're going to lose all credibility and the prosecution is going to win the day. So I think they have to stick with the original narrative put forth by their client.
So what actually sunk it for the defendant here? Let's not even try to get into the whodunit here as to exactly who or what caused the injuries here. But it seemed to me during the interrogation recording that the defendant kept saying over and over and over again that he didn't know what happened, that he saw this thing coming towards the windshield, and that he sort of reflexively went to block it, okay? And ultimately, he couldn't fill in a lot of the blanks. He kept saying over and over again, I don't know exactly how that happened. Here's what I do know happened. I know that the thing came towards the windshield. I know I tried to block it. For like a split, tiny 1/1,000,000th of a second, I thought maybe it was a bird, because what else would be flying through the air in front of a car windshield? Then he realized it was a pipe. It crashed through the windshield. His wife started flailing. He whips around onto this side road, stops, parks, and that's where he calls 911 eventually after getting her out of the car and trying to give her some first aid. He kept saying, I don't know, I don't know, I don't know, I don't know. And the interrogators basically just got him to start speculating as to what may have happened. And he kept saying, well, I don't know. This may have been what happened.
Right.
Is that the danger in the interrogation? Perhaps it would have been better for him to just clam up, invoke counsel, and shut the thing down. But he kept kind of speculating, and it's clear from the interrogation that he's speculating. And now they're trying to say, well, that's his version of the story, and it couldn't make sense. Well, even he said in the interrogation it wouldn't make sense because he didn't know. He said he was speculating.
And, that's always the danger with answering questions, is that you may say things, whether innocently or not, that the investigators, that the prosecution can use to make you look like you're guilty, to make it look like you're hiding something, whether you are or not. It's always best to let your lawyers handle the situation, to invoke your right to remain silent. I think that's always the best way to do it. And I think his testimony, which should be coming up soon, is really going to tell us whether or not he looks credible on the stand. His credibility is going to tip this case one way or the other, because I think even though most people believe he's guilty, the prosecution hasn't been able to put forward an airtight case. And if he looks like a liar, if he looks like he's hiding, if he looks like he's not being truthful with this jury, that's what they need to convict him.
I agree. So, I'm trying to characterize this case because we've had some other cases recently here on the Law&Crime Network that to me seem like pretty slam dunk convictions, and lo and behold, they were. So this case, a lot of people are saying he's guilty, but I don't think that it's slam dunk. If you were to characterize it on a percentage scale or a 1 to 10, wherever you want to put it, do you think the state has a slam dunk case here? Or do you think that the state has maybe 70% of a case, 65% of the case, theoretically still passing, but how would you characterize the state's case here?
Well, since we're using basketball analogies, I'm going to say it's not a slam dunk. It's more like a contested jump shot, right? It's a mid-range jump shot. They've got a hand in their face. But if they're really good about it, they can hit the shot. But it's not the easiest shot in the world. I think when I look at this case, if I were to give it a number, I would say the state has about a 60% chance here. And here's why I say that. Because their case is not based on saying he did this and here's the evidence that he did it. They're saying we believe this happened because the things that he's saying aren't true. He would not lie otherwise than he was guilty. So that's kind of what their case is based on, is that if he were telling the truth, or if he hadn't killed her, he would have just told the truth. He's lying, therefore he's guilty. That's the tough thing to prove for them because they have the burden.
So one of the lessons here, ultimately, we're going back to what I said before, and that the defendant should have just not gone into this speculative session, also known as an interrogation, where they could try to take his yarns and use them against him, because that ultimately seems to be what they're doing here. It ultimately raises questions about interrogation. But yet we're stuck with what we've got, and that initial interrogation and the original statements at the scene to the investigators are basically, one could argue, have handcuffed or put the defense in a straitjacket, and they really can't wiggle out of them.
Yeah, I mean, the defense has a tough job because the story and the account he's given, at least in my opinion, is quite far-fetched. That this pipe from a vehicle going in the opposite direction bounced into the road and went through the windshield. We saw the numerous trying to reenact this thing. The pipe barely even got a few inches off the ground when it bounced off of the truck. Here he's saying it bounced 4 feet into the air, came right through the windshield. Seems really out of place. There's the EMT workers that talk about when they got on the scene, the way her body was positioned did not match with him saying he gave her CPR. There's the fact that there was no blood on the pipe that they could find, that they found the glass on the seat, on the passenger seat inside, where her body should have blocked that if she was sitting there when the pipe came through the windshield. So the inconsistencies, the unbelievable points of his story, I think, is what the prosecution must use if they plan on getting a conviction.
Look, I think the weakest point in this, and Andell, I think we lost your camera feed again. We can hear you, but we can't see you. I'm not sure if that's something on your end or if it's on ours, but I'll try to keep going here as best I can. So I agree that this bouncing of the pipe is the issue for the defense. If the story was that this pipe rolled off of a passing flatbed and went straight through the windshield, I might be drastically more inclined to buy it. But how else did the pipe fall here? Did it fall straight off the thing? Did it somersault? Did one end of the pipe kind of slide off the end of it, and then it sort of somersaulted back into the car windshield? I don't know. But the whole idea of the pipe bouncing, I have a hard time believing.
Right. I mean, it just doesn't seem to make a lot of sense. A pipe falling off a truck and bouncing 4 feet into the air, it just seems too far out there to be believable. And I think other issues that he has is that there are so many, the people that don't have anything to do. The passerby says he sees the car in the ditch, there's no one there, the windshield's intact. Those are all things that we have to deal with, that the defense is going to have to deal with.
Yeah, exactly. We are starting to get some activity in court. It looks like people are starting to file back in, but I don't see the judge on the bench quite yet. Should let everyone know that from what we are hearing here at Law and Crime, after this expert witness in biomechanics wraps up, we are expecting the defendant to take the stand. That's what we're hearing. I'm wondering if they're going to try to get the defendant on the stand this late in the day today, or if this is something that might spill into the day tomorrow. But keep in mind, this trial is in Wisconsin, so it's an hour behind where we are here in the Eastern time zone. So it's about 2:40 in the afternoon there right now. Andell, if you were defending this particular individual, would you want to put him on the stand this late in the day and kind of let the jury go home and mull over everything that he said as the last witness on the stand? Or would you prefer to put him on the stand first thing in the morning?
Well, it all depends. Number one, the judge runs the courtroom and the way that process is going to go. Whether you want your witnesses on now or later isn't always taken into consideration. But in this case, it really depends on how strong of a witness you think your client is. In this case, if you think he's strong, then why wouldn't you want the jury to have his words as the last thing on their mind today? To have that impression of him telling his story, talking about how he loved his wife, talking about what a tragedy this was, and
yeah,
this
Andell,
was an accident.
Great. We've got action in court. It looks like the jury is coming back into the courtroom right now. I know you want to hang on with us and wait and see where the afternoon goes, but let's go back live to La Crosse, Wisconsin. Again, the Todd Kendhammer case. The jury is just coming into the room. This is the case of a man accused of first-degree intentional homicide.